Hello, it's Phillip Taylor from Richmond Green Chambers speaking, and I'm looking at another book in the Arbitration series from Informa. This one is quite a heavy tome. It's Arbitration Act 1996, the 4th edition by Robert Merkin and Flannery. It's an Informa publication. It has the Act in detail. You can see from the book it's got the standard contents at the front, and it goes through the Act in some detail, and you can see the thing that is most important about this book are the notes. You can probably see them there. A lot of footnotes as well, and cases, and towards the back we have the appendices, the various appendices, and then we have a very useful index. It's quite a heavy book, as I say, about 370 pages, something like that. My wife and I have written a review of this, which is on Flickr, and we've given it the title, The Definitive Reference for the Practitioner and Arbitrator. It is actually a referencer of some sort. This is what we say. In the words of Merkin and Flannery, the Arbitration Act 1996 was intended to be both a fresh start and the closest thing to a definitive code of arbitration law that has ever been enacted in England. This book is the definitive referencer for the statute, and that's exactly what it does. The 4th edition, published at the end of 2008, follows the publication, of course, of the Act itself in 1996, which was called an Annotated Guide, followed in turn by a 2nd edition in 2000, and then a 3rd edition in 2005. All by the same people in terms of the note contents. Even in the 3 years that have elapsed between the 3rd and 4th editions, so much new case law has emerged that a new edition of this definitive work became necessary, and with it a view of taking a fresh look at the Act. The 4th edition, in our view, endeavours to cover all the major decisions emanating from the English courts, and in particular the Commercial Court and the Technology and Construction Court, as we now know it, where most matters relating to arbitration are commonly heard. It's an outstandingly helpful feature for the practitioner, for members of the Chartered Institute of Arbitrators and those involved as arbitrators, to use the detailed notes which I've referred to before, because they explain the meaning of the section and cite the relevant cases which deal with the interpretation of the wording of the section, which can make some sense to us as the users. So whatever section of the Act you're looking for, you have the expert views of meaning interpretation on hand. Now, as a clear and comprehensive review of the present state of the 1996 Act, this erudite volume excels, in our opinion, because the deliberations that led to the passing of the Act are well explained and its provisions well examined. There are specific CPR points which affect applications to the court, and also included, of course, is the full text of the Act, and it also refers to the Departmental Advisory Committee reports. In particular, and in addition to the wealth of new cases, there are 3 cases included which illustrate several issues of principle concerning the Act. That's the Fiona Trust, West Tankers, and the Lesotho Highlands matters. Now, I think you'll find that they're obviously dealt with in some detail. These issues have been aired in the House of Lords, as it then was, since publication of the 3rd edition. As you would expect from an authoritative work of reference such as this, there are extensive tables of cases and legislation, 4 schedules, 9 appendices, and, as I say, a comprehensive index at the back, which of course is extremely helpful, especially for the abbreviations. The book incorporates cases decided up to October 2008, and it highlights the definitive nature of this reference, so that such useful cases are actually included, and I think certainly it eases the work of the arbitrator enormously. So thank you very much, Informa, for informing us about this. Thank you. Bye-bye.